All right, welcome back. How to read law. In many instances, individuals are burdened by the notion that law is difficult to read, interpret, and to express. Law is a difficult area or subject. That's why it takes 4 years to study the theory of law and then 1 year at the Legal Training Institute to understand the practical aspects of the law. After that, you're admitted as a lawyer in the National Supreme Court of Papua New Guinea. Basically, what we'll do is that we will sort of enable you, excuse me, in these classes to understand the different sort of methods and practices and pointers on how to read law. All right, legislation. So legislation is a general given to the Constitution, Acts of Parliament, organic laws, emergency laws, provincial laws. So when you see legislation, you will know that it's drafted into chapters, sections, and subsections. For instance, even in the event that you are to look at Section 2 out of Section 2, Subsection 2 of the Income Tax Act 1986, you will automatically know that the provision is in Section 2 and Subsection 2 of the Income Tax Act 1986. To locate this provision, you go into the hard copy of the legislation or soft copy of the legislation. Soft copies are available on packley.org. And then under consolidated legislation in the packley.org there, you scroll down and you open the legislation. And then you go down to Section 2, Subsection 2 to locate the provision. When quoting a provision of the legislation in law, you cite word by word. You cannot paraphrase, you cannot subtract, or you cannot add any words to a legislation. You have to quote it as it is without any change or paraphrase. So now, let us look at the piece of legislation, the Public Finance Management Act. All right, you would note that the name of the act is the Public Finance Management Act. It's referred to as the short title. After the short title, you find the year of publication, 1995. When describing the statute, use the short title and the year. Under the category title, preliminary, you'll find a short explanation of the content of the legislation. It should help you as a guide in determining what different sections of the Act are. Take a moment to examine the screenshot of Part 2, Section 3 of the Public Finance Management Act on the next page. So we looked at Part 2 in the content page. It says that it talks about responsibilities of the minister. Or if you scroll down, you would see the section itself basically explaining the responsibility of the minister. All right, you will note that the general section is provided in the preliminary and then it's further broken down into sections and subsections. Each section contains a different law and is explained in detail what the provision stands for. In picture 1, you have the main section of the law, example section 3, and in the section in the second picture, you have section 3 being broken up into subsections to provide the necessary responsibilities of the minister. Legislation should be read precisely and carefully. A golden rule to note is that statute means exactly what it says. I remember Prof. Luaki's favorite saying, law is what it is, not what it ought to be. Do not add or remove any word from the legislation. All right, now how to read and study case law. Case law, the ability to interpret the case in Papua New Guinea is especially important. Cases are the primary interpretation of judges and magistrates, and to understand the case, it's important to understand how a case is cited. And in PNG, you will find the different types of citations, and I will give you as we go along. All right, the highest sort of category of a case is a Supreme Court reference. So this is basically a peculiar case that is a case which asks the Supreme Court to interpret certain provisions of the Constitution. All right, the example I have used there is SCR number 3 of 2011, referenced by the ECP provincial government. If you see the word SCR in front of the case, it's a peculiar case known as the Supreme Court reference. This is provided under Section 18 and 19 of the PNG Constitution and can only be initiated by someone of standing. So the Supreme Court references, not anybody can go and apply for these cases. It must be done by the opposition leader, Prime Minister, Ombudsman Commission. And in a typical Supreme Court, you will have Supreme Court reference. You have the referrer, is the party initiating the case. So in the above example, is the reference by the East Pacific provincial government. So they are the ones that are initiating the case. So in the above case there, you would note that the Supreme Court is basically being asked by the ECB provincial government to give a decision. All right, famous Supreme Court cases include the declaration of the Manus Asylum Seeker Center as unconstitutional, the also the election of Prime Minister James Marape. In this, the Supreme Court is asked to measure an act by the executive legislator against the Constitution and whether it is not in accordance with the provision of the Constitution. This act may include policy decisions, like the PNG government's ability to agreement to build the Manus Asylum Seekers, and also may include legislation passed by Parliament, or even actions that are taken on the floor of Parliament. For instance, the decision to remove the late Somare as Prime Minister because he was ill and in Singapore, and also the decision for the government to reconvene Parliament when it had already been adjourned. So this type of cases is where the Supreme Court is tasked to review certain legislations or acts, or policy acts by the executive or the Parliament. All right, now you see a case of Supreme Court case, so SC 2055. So HBS Limited versus Manda 2021 PNG SC 1. When searching for a case, if you use the word SC, it stands for Supreme Court. That means the matter is in the Supreme Court. The case may have been decided in one of the lower courts, in the District National Court, and has been appealed to the Supreme Court. In the above case, the HBS Limited is the appellant. So the appellant is the party appealing to the Supreme Court, while Manda is the respondent, the party responding to the appellant's claim. This case was decided by PNG Supreme Court in year 2021. All right, let's look at the next one. It's called Accident Investigation Commission versus Kintao 2021 PNG NC1. So when you see the word NC, you know it's a national court decision. And also you know that this case happened in the national court. The person bringing the claim, in this case, is the Accident Investigation Commission. They are known as the plaintiff. And the person defending the claim is Kintao, is known as the defendant. All right, then we look at the other case of Tapugun vs. Lao, PGDC 4. The initial DC means district court, and in the above case there, Tapugan is the party bringing the complaint. We call him the complainant, and Lao is the defendant. We call him the defendant. All right, also in PNG, because of the application of the common law, you find different types of cases as well. So you might see cases like John vs. Peter CLR 45. CLR stands for Common Law Reports. Met vs. Ryan 2KB means 2 King's Bench. QB means Queen's Bench. And OLR stands for All England Reports. All right, now we look at how to brief a case. This is the standard method. So the first and the most important thing is the citation. This helps you identify who the parties to the case are and in which year the case was decided. The court is where the case is instituted and important when trying to brief a case. Right, procedural history is what are the processes in the case, whether it's started in the district court and now it's in the national court, or it's started in the national court and it's in the Supreme Court. So it basically gives you a brief process on the history of the case, the procedural history. All right, facts. Facts are very, very important because they are factual recount of events that happen in the case. It is important to have a summary of the pertinent facts. The fact is where the law is applied to and where issues are derived from to be resolved. A good case has the following facts: a descriptive nature of the case and a summary of what inspired. If the case is originated in the lower courts, a summary of what happened. So facts of an armed robbery case will include the accused, videos being seen by eyewitnesses or recorded on camera robbing a store, hotel or club, house armed with a gun. It includes the time, the date, and the description of the crime scene, and also the accused. In a civil matter as a breach of contract, it is important to include whether the contract was written or oral, the evidence of performance. For instance, if Tanda entered into a contract for the purchase of car with Peter for 5,000 kina, however, if Tanda received the money and does not deliver the car, the important facts will include the contract, when it was signed, when Tanda received the money, the receipts, and how he failed to deliver the car to Peter as per the contract. All right, the issues now are questions of law that are raised by the peculiar facts, and at times it is expressly stated by the courts in most instances in a question form. So following the above example, in the case of the armed robbery, the issue will be whether or not Vitus is guilty of armed robbery. And in the civil case of breach of contract, the issue will be whether or not Tanda is liable for breach of contract. In cases with multiple issues, the court will look at answering the issues to reach a judgment. All right, ratio decidendi. Ratio decidendi is the reasoning behind why the courts come up with a decision. A judge has to give the rationale that is the chain of arguments that led to the judges or judge ruling the manner they have. So what will happen is that, for example, in the armed robbery case, the judge may view the evidence, placing visitors at the crime scene, holding the gun, and even being captured on camera orchestrating the robbery. This is substantial evidence, so the judge will use the provision of the criminal code to determine the actions of victims, satisfy the elements of offense of armed robbery, and will highlight the law and will convict victims for the offense. In the civil case as well, it is the same. So always ratio decidendi, the judge must give a reasoning for his judgment. All right, obiter dictum, sometimes the judge can make statements that is not related to the decision, that is not a essential part of the decision, but it's not legally binding. So they can make public policy statements or stuff like that. We call them obiter dictum. The decision is the court's answer to the issue. So in the criminal case, it would be whether or not Vitus is guilty. The court will say yes, there was elements of armed robbery was satisfied under criminal code. Vitus is guilty of armed robbery. In the civil case, they will say that yes, Thunder has failed and there was a breach of contract. So after that, the court will grant the remedy. So for instance, the court will make formal orders. In the Vitus case, they say you are convicted, and then they will sentence him to prison. In Thunder's case, they will order a specific performance of the contract or the money to be returned as well. That is what we mean when we say how to brief and summarize a case. All right, thank you very much. Your next classes we will cover is property law, and I will make videos as well. Thank you.